Welcome to Shift, everyone. We are very pleased today to have two great guests, criminal defense attorney Joe Friedberg and retired federal district court judge James Rosenbaum. And I want to sort of get to a little bit of your backgrounds and ask you, Joe, have you always been a defense attorney?
Yes, I'm not very good at anything else, and I've never prosecuted because I never wanted to work for a government. I spent a very brief period of time with a Wall Street law firm, and the first day I went to work, I knew I couldn't handle it, so I stayed there about 8 months.
And you then?
Well, I quit practicing law. I came out to Minnesota to resume something I had done all the way through college and law school. I was an encyclopedia salesman. And a friend of mine I'd worked with in North Carolina was out here. And I called him one day from the Wall Street office and I said, I can't handle this. I don't like it. And I don't like the people I'm working with. I don't like the people on the other side. And I don't like my environment, even though I grew up here. And have you got a spot for me? He said, yes. So I quit and left my wife and baby in New York and came out and started selling and managing an encyclopedia operation, which I really did for a couple of years until I took the Minnesota bar. And, my first couple of years practicing, it was all criminal work, and I never took a fee, not because I was that charitable, because nobody that I represented had a fee. And then around 1968, 69, dope moved to the suburbs, and people started being able to pay me, and I developed a criminal practice. That's probably it. It just went on from there.
Jim, how about you?
I started out wanting to be a doctor, and there are many people today healthier and happier and stronger because of how I did in physics. That career was not going to work out, and I had to find something to do, and I went to law school. I had no particular interest in being a lawyer. And then I wound up as a Vista, and I was in Chicago and working at a civil rights organization dealing with housing mostly. And this is right out of law school. And this fellow came in and described he was an African-American, and he'd gone and responded to a newspaper ad. He responds to the newspaper ad, he goes to the place, and there's no apartment for him. And we sent in a tester, and the person said, oh, we got 11 places, and we can show you all over these places. And he described that, and I said, so he's telling me this story, I said, well, we better get you to a lawyer. And one of the people looked at me and said, you're a lawyer. And I said, oh my God. And after that, I fell in love with it. It was really fun, and I enjoyed it. I did that for 3 years and practiced in Chicago. I'm a St. Paul kid. There's a rule for St. Paul kids. All St. Paul kids go home. So I moved home, at least back to Minnesota, and I practiced general trial law, did all kinds of stuff. The firm that I was with represented St. Louis Park for a criminal. So I prosecuted, but I also did defense. And I did that for, I guess 7, 8 years. Hung a shingle, and then I became United States Attorney in 1985. So then I was the chief federal prosecutor and did that until from 81 to 85. And in 85, I was appointed to the bench. It was one of those careers that, a little like Joe's, I didn't exactly plan it. It just kept happening. And I was not well trained for other trades. So I sort of stuck with the one I was in.
Well, I invited you both today because you have that wealth of experience. And because the Derek Chauvin trial, which is scheduled for March 8th, is pretty complicated.
I hadn't heard anything about it.
You haven't heard anything. Well, I think Joe will be able to school you a little bit on that.
I hope.
But lots of comings and goings with that. And a couple weeks back, the New York Times reported that the former U.S. Attorney William Barr had rejected a plea deal that reportedly Derek Chauvin had said he was willing to plead guilty to murder. Joe, what did you think of that story?
Well, first of all, it's certainly newsworthy. Second of all, if it's a lawyer or someone who's under a lawyer's control who told that to the reporter, he or she should be disbarred. Because that really, really makes jury selection difficult, if not impossible. Can you imagine questioning a prospective juror who knows that Derek Chauvin was willing to plead guilty to murder and asking him if they still can presume that he's innocent of the murder he was willing to plead guilty to? That's an impossibility. It can't be done. The other thing is that percentage of people that won't know about that leak, if we can call it that. How do you bring it to their attention without prejudicing them, without telling them about it? That's walking on glass. So I don't know what they're going to do. It strikes me that anybody who knows that he was willing to plead guilty and go to jail for more than 10 years, as the story indicated, could not possibly be a juror in that case. No matter how much they promise to put that aside and be fair. I've thought for a long time it's going to be very, very difficult to get a jury in this case in the first place. I've thought it would be a heck of a lot easier to get a jury in federal court where he could be tried for a civil rights violation if the U.S. attorney can get the grand jury to indict him on it. Because then you've got a statewide jury. And in addition to that, if you can't get a fair jury statewide, the Chief Justice of the United States Supreme Court can find a venue where you can, and he can move it where he pleases. That's been done before. So I have always kind of thought, based on the overwhelming publicity in this case, and this being the final nail in the coffin, that this case should be in federal court and probably should not be tried in Minnesota.
What do you think, Jim?
It's interesting. Joe said it's newsworthy, and the slogan of the New York Times is all the news that's fit to print. And this really tests whether what was advanced by this story. What would be helpful to either the trial or to justice, or at that moment, since presumably, as Joe said, he thought that whoever's disseminated that kind of information ought to be penalized for it. I guess I don't have any comment about that, but it really goes to the core of what is useful and what is fair. And it raises a question of, is that fit to print? But okay, it's there. I have tried cases with enormous visibility. The most popular of them, and now was a long time ago, was the Northwest pilots who flew from Fargo to Minneapolis drunk. And Johnny Carson talked about it in his opening monologue virtually every night for a year and a half. And you can find a jury. There's a remarkable number of people who don't follow the news. And particularly when you're in the broadcast media realm, you tend to believe that everybody reads and listens to what you said.
Oh, yes,
And
we do.
and they don't.
No.
But this really is a problem. This venue, this veneer, this group of people who will hear this case will be from Hennepin County, almost certainly. The Fed draws from a statewide panel, and it will be difficult. The other thing is, this is in state court. In state court, the examination is done by the lawyers with very little input from the judge. In federal court, it is almost all done by the judge with very little input from the lawyers. And the lawyers in state court tend to basically want to try their cases out on the jurors as they're selecting them. In federal court, Joe will tell you how frequently that happened and how frequently that was permitted.
Never by you, I can tell you.
I can assure you. And the great federal judge, Ed Devitt, would pretty much come in and say, "Good morning, is everybody fair?" And they'd all say yes, and he'd say, "You can select your jurors now, counsel." Jury selection in state court, in this case, would be, I will be quite surprised if it doesn't take 2 or 3 weeks. In federal court, how long would you guess, Joe? We did a trial. We did one a week.
Yeah, I think it would take a week and a half to get a jury in federal court. I'm not sure that that 2 months is enough time in state court for this.
Yeah, it's a good time, but I think in Ferris Alexander, I think there we examined the jurors one at a, I think 3 or 4 at a time. But they will bring in a panel, I would suspect, of a very substantial number. I'd be surprised if it's under 100.
Well, I think it'll be considerably more than that, but they're kind of come into the room one at a time and go up on the witness stand. The judge will question them probably for 10 or 15 minutes and then turn them over to the lawyers. My guess is the judge will end up having to disqualify a significant percentage of them. There's a questionnaire for everybody to go off, so it's going to be a very difficult task. Different than most cases, and certainly we both had many high-profile cases. I don't think there's anybody in Hennepin County that has not seen the Floyd video. And if you see it, you have an opinion about it. And that's a difficult thing to get around.
So if you're looking for a potential juror, Joe, Judge Cahill has asked the questions and they're still in there. You want to try a couple of questions that you would ask a potential juror on Jim?
Well, all right. Mr. Rosenbaum, have you watched any of the video in relation to this case?
I think it was on the news pretty much in the summertime, and I remember seeing a lot of it.
Do you remember what happened to Mr. Floyd and how it appears to have happened?
I know that he was on the ground, and I know there was a police officer next to him.
Did you form any opinion as to the conduct of the police officer at that time?
See, now you're back into an interesting place, because in federal court, Joe would never get that question out.
I can't ask it, but here I can ask this and a lot more worse ones.
And you really have, other than, these are real interesting issues, and you start to get into wanting to try your case and trying to soften up the jurors' views. And that is not reserved only for the defense counsel, that's also for the government counsel too.
And you play the game Jim, sorry about that. And you asked Joe some of the questions that you would get to if you were the prosecution.
Have you ever been stopped or apprehended by a police officer?
Yes,
Do you know anybody who has besides yourself?
yes.
Can you tell me what was your experience and what was your contact and your relationship with the officer who detained you? Can you tell me a little more about that?
Oh, we spent several minutes discussing what the reason was for his stopping me and what he claimed that I did.
Did you agree with whatever his view was of what happened?
No,
How did he treat you?
politely.
Did you and he have any kind of confrontation?
No,
Did any of your friends ever tell you that they'd had confrontations with police officers?
oh yes.
Now, when you were with those people, or when you were apprehended, was anybody in the car other than whatever race it is that you consider yourself?
Yes.
How was that person treated?
Well, he wasn't treated. He was in the back seat and he was just looked at.
Okay. And did you and that person, was that a male or female?
Male.
Did he describe to you his own views about how the officer treated you?
No.
Okay. Have you ever had a less cordial relationship with a police officer?
I'm a criminal defense lawyer.
So you're Jim. What? Oh, you're out. All right. So
Yes, I have had, in my lifetime, I've had numerous
Several.
conversations, yes, with police officers. But out in the street, no.
All right. And then you would, I might well ask questions about drug use. If I was familiar with somebody either having used drugs or the effect of particularly drugs that suppress either breathing or their blood pressure, I might ask questions along that line too.
You know, if you want to know if I'm a prosecutor, who I want on this jury,
yeah.
I want to know who they voted for in the last election.
And that I cannot imagine being allowed in either court.
I can't ask that question,
Yeah.
but I think I can figure it out
Right.
by asking jurors questions. And if they voted for Donald Trump, I want them on this jury.
Yep. Law and order.
Yeah, and more than that.
It depends on
And more.
it depends on who's advocating for what law and order issues.
Yeah. I mean, I believe that I have enough insight into human behavior to be able to figure out when I'm questioning a person with the latitude I'm given in state court. I think I can figure out where they stand politically. And I want as right-a-wing jury as I can get.
You might ask what bumper stickers they have, which is a question that is not infrequently asked. Those kinds of things.
Yeah. However, when you do that, let's suppose the guy says, "Make America Great Again," and I got 4 Trump stickers. And once you bring that information out, the defense has got enough information, they're going to strike them. So you're going to try to be a little bit more subtle. I go back to the 2 bumper stickers I had on my car during the Vietnam War. One said, "Support our fighting men in Vietnam," and the other one said, "Mary Poppins is a junkie."
But actually, what the other thing that Joe's pointing out, however, is extremely important. You don't pick people on your jury. You can only pick people off your jury.
Yeah.
And as I used to describe it, you only have so many bullets. You don't know how many you've got. You know, the judge will tell you before you begin. There'll be, the defense lawyers have typically a larger number, but you've got a limited number. And I cannot say, Mr. Jones, I really like that person. I want him on my jury. Or Ms. Johnson, I really don't care for that person. I want her off. I can say I want her off, but I can't say I want her on.
Mhm.
And there's also this chess aspect where you would like, if you really like somebody, you want the other side to not know you really like them.
Yes. And there's two challenges. If you can get somebody to say, like, I don't like black people, period. Well, obviously, you're going to be able to challenge that person for cause, and it doesn't cost you one of your challenges. By the same token, you want to hide your feelings, as Jim said. You want to hide your feelings as much as you can, and appear undecided about jurors that you really want. Occasionally you try to make the other side think you don't want a juror when you really do. It's a chess game. I think it is going to be a more volatile one in this case than usual. But in the last analysis, there are people who make a living by advising lawyers on who to select for juries.
I've always wondered how they bottle the snake oil, but I know they do very well, and some of them are highly regarded.
Yeah, there was a TV show called Bull,
You know,
which
Still on.
yeah, well, the problem with that is that with all the help that Bull has and all his technology, it would cost you about $5 million a case to employ him in his operation.
Yeah.
But
there are people who have the kind of assets and the wherewithal that they pay that kind of money. And there are people, they not only have mock trials, they have mock jury selections, and they are, in many cases, they will know the demographics of the community, and they will also do things like in court, when a person shows up and Mr. Jones says, my name is Wally Jones, they immediately start Googling and looking into Wally Jones. With big data, there's a lot of information out there, and it's accessible in a darn big hurry.
Right. So in this case, we have the prosecutor being our Attorney General, Keith Ellison, and we have Chauvin's lawyer is Eric Nelson. Okay, so how sophisticated are these guys?
well, I don't think Keith Ellison's going to try the case. He was a competent trial lawyer, but I don't think he's going to be in the courtroom. Eric Nelson.
Say that as that it's the Attorney General's office.
Yeah, but he also has got
Is it Steve Schleicher?
Steve Schlesser, who was a good federal prosecutor, a man named Matthew Frank, who has a reputation as being a decent trial lawyer. He's also got some big firm people from Washington, and my reaction to that is that doesn't help you. Anytime we can get a New York lawyer in the courtroom, we kick them around for a while before we send them home. But,
It's like you got to know the territory.
yeah, they're.
But also, that person, I have no opinion about him. I've never met him, but I think he was a deputy solicitor general.
Yeah.
They tend to be law professor types. They are trial work is very much an art of being able to communicate, and law professors typically have not been successful trial lawyers. That doesn't mean he's not, but my guess is that's not his competence. His field is the law, the academic side of it, and those kinds of issues. That, and I don't know. I mean, maybe he's going to be lead examiner. I really don't know. But
Well, I think he's there for his writing ability and his legal analysis.
that would be typical. Slisher's a trial lawyer. Joe is a trial lawyer. I was a trial lawyer. They tend to, one of the skills that they have is to be able to reach across to get to those jurors on a personal level, if you will, so that the credibility that you have may carry, at least make them amenable to accepting the arguments that you're going to be advancing.
Eric Nelson is a good, competent, younger trial lawyer. He's had some successes. He knows what he's doing, and he's devoted to this case. He'll be fine.
I don't know him at all. I've never worked with him, and I've never met him. Our practice is never interlocked.
All right, how about Judge Peter Cahill?
Judge Cahill's been around a long time, and he knows his job. And I think he was a criminal defense lawyer. Joe, did he do some prosecution too?
He did both. He was with Mike Kolich as a defense lawyer, and then he spent a long time with the Hennepin County Attorney's Office. With Kolich, he also did some prosecution, I would assume, for St. Louis Park. But he's a good judge. He's a smart guy. He's a nice guy. I've never had any criticism of him. And frankly, he's certainly in the upper echelon of Hennepin County District Court judges.
Okay, so let's get to sort of the matter at hand. And that seems to be a bit of, well, if not a moving target, it's an expanding target. So on Monday, the Court of Appeals is scheduled to listen to the prosecution, ask if they can add third-degree manslaughter.
Third-degree murder.
Yeah, thank you, murder. So why would they be doing that?
Well, certainly they're not talking to me about it, but I have my theory. Third-degree murder was charged in this case originally by Hennepin County. There isn't an academician around or a knowledgeable lawyer around who wouldn't have told you prior to the Noor trial that third-degree murder just absolutely, without question, doesn't fit the factual circumstances in Noor, and much more so here. In the Noor case, he was convicted of third-degree murder, and the Court of Appeals affirmed the conviction in a 2-to-1 vote. I don't know if Judge Rosenbaum has read the opinions or not, but the majority opinion is a tortured, strangely written opinion that sets out to affirm the conviction and runs all over the place trying to do so. It's a 2-to-1 decision. The dissent is well written and easy to understand. Third-degree murder didn't fit Noor. I think the Supreme Court will probably reverse the Court of Appeals on that. It certainly does not fit this case. Third-degree murder does not fit when there's an identifiable victim. Third-degree murder was a statute that was passed for the guy sitting on the side of a hill, shooting into a passing train, not knowing who he was probably going to kill or maim. They want it because it gives the jury an out. And the strange thing about it, the way this case is charged, the punishment for third-degree murder is the same as it is for second-degree murder. The guidelines are exactly the same, 150 months. The statutory maximum is a little different, but we sentence according to the guidelines, and it wouldn't matter whether the jury convicted of second-degree unintentional murder or third-degree murder. The sentence would be the same. It it's there so they may get themselves a compromised verdict, because at the moment, the way it's charged, the compromised verdict is second-degree manslaughter, which is a negligent homicide. And if Chauvin is convicted of second-degree manslaughter, the state will look at it as a total and complete loss, and I expect the city of Minneapolis will be burned to the ground. I think that they're trying to take advantage of a ruling that they got from that Court of Appeals so they can get a compromise to the jury. And I hope it doesn't work. I don't think it will.
It's interesting. This is the fifth pretrial appeal to the Court of Appeals. Joe, I don't know how many criminal cases you've had, but how many have had more than one trip to the Court of Appeals before verdict?
I think I've only had 3 in my life where there's been one trip. Yeah. And I've tried 350 cases. This is like a snake in its death throes, as far as I can tell. What I really hope is that they don't get relief. The problem in my mind is what judge is presiding on this. I've never known of Judge Michelle Larkin to do anything but affirm a conviction or rule with the state. The Supreme Court is probably going to take the Noor case up. They certainly should. I don't know what's going to happen with this, but the state has two things in mind here. One is getting third-degree murder in, and 2 is getting themselves a continuance.
This summer, I talked to, former police chief Tony Boza, still around. He said they're not going to get a conviction. It's going to be mayhem.
I happen to agree with that. They have huge cause of death problems. Where a police officer is doing his job, even if he's doing it more enthusiastically than he should, but there's an alternative cause of death, as there is in this case. I don't think they're going to get the conviction they're looking for. This is a difficult case, far difficult than the world believes it is, and that's what the problem is.
What do you think is going to happen?
I think there's going to be a verdict that's less than second-degree murder, less than murder, be it the jury's going to have to be given the choice in this case of first-degree manslaughter. They already have the choice because the prosecution put it in there of second-degree manslaughter. One of those 2 is likely if there's a conviction, I believe. I think there's a significant possibility of an acquittal because there's a case to me is somewhat analogous. You remember the Casey Anthony case in Florida? The young lady whose child was found buried, child was missing, and it was clear that Casey Anthony had told lie after lie after lie about it. And she was just a deplorable individual. And the belief was that she killed her child. The reason she was acquitted is they couldn't prove the cause of death. They couldn't prove under what circumstance the child died. They didn't know if the child was buried alive, if the child had died somewhere else and then been buried, and they didn't know what caused the death of the child. The jury had no choice, despite the fact they hated her. They had to find her not guilty. In this case, the proof of the corpus delicti, which is that death came about by criminal means, is going to be very, very difficult. I've never seen a case where apparently the prosecution has got 7 or 8 forensic pathologists on their witness list, and I believe the defense has just as many. Well, if you've got dueling forensic pathologists over the cause of death, that almost sounds like reasonable doubt, the definition of reasonable doubt. We know by this time from news reports that Mr. Floyd had a lethal dose of fentanyl in his blood. We know that he had prior existing conditions, arterial sclerosis and heart problems. We know that he had committed a crime, a felony. There's all kinds of things that make this very, very difficult for the prosecution. Whereas the general public view at this point is that Chauvin choked him to death. And I think there's been enough evidence leaking out that that's probably not going to be that clear.
To some extent, this really points out, you open up the morning paper and you read about Joe Blow did X to his wife or whatever the heck it is. And you say, well, that guy ought to go and he's guilty. But a courtroom is not reading the morning paper. It may be minute by minute, second by second analysis of what happened, when, and why. And it changes. It's no longer an incidental. It now becomes an intensive examination. And both sides, highly competent lawyers, are trained to focus on those kinds of things. And you bring in a group of lay people, 12 people, and I do not at all, I want to be very clear, do not disparage them. Gary Peterson, who was Hennepin County's medical examiner and a doctor and forensic and a lawyer, said on questions of scientific fact or mathematical issues, 12 people have a collective IQ, I suppose, around 100. But on questions of lying, cheating, and stealing, they have a collective IQ somewhere around 180. And the other line is that when you get 12 people and they're working hard, close the door and the Holy Ghost descends on them. They work hard. We had a case many years ago, what's the bank case that Hubert Humphrey's son-in-law was involved in? And it was a major criminal prosecution.
Was it a federal prosecution?
Yeah.
Was it Midwest Federal?
Yeah, it was Midwest Federal. And Solomonson is his name.
Yeah, I tried that case.
Well, all right. Then you will know how many counts there were in there and how many documents there were and how many lawyers on both sides and FBI agents did it. And the punchline was, in the middle of the jury's deliberation, which went, I think, almost 30 days.
It went 5 weeks, Judge.
The jurors came out and said, I think this check is involved in 2 different counts and it should only be in 1, as I recall.
Yeah.
And all of the FBI's forensic accountants and all the accountants, the jury assembled the evidence in a way that nobody had ever done before. And these are 12 people off the streets. They take their job very seriously.
I like to say that to jurors that they become better people than they've ever been before, and you have to say that without insulting them. And they do take their job extremely seriously, and they're going to. I mean, this case, this jury is probably going to be. It's going to be an anonymous jury to begin with, and they're probably going to end up locked up.
Yeah.
Well, my guess is that they may well be sequestered through the whole trial.
And maybe not in downtown. No, because of the barbed wire and the concrete road.
I don't want to even speculate on where they're going to take them, but they're going to be locked up for 6-8 weeks for sure.
In federal court, it would not be uncommon when we had a jury that needed that kind of various sorts of protection, if we had a trial in Minneapolis, they would meet someplace in St. Paul and would be brought to the courthouse, and nobody would ever know how they got there or where they were.
Yeah.
Kind of like
That,
they did when they were.
that should happen here too.
Yeah, yeah.
I mean, I'm thinking for a second, how would a Black person feel on this jury if he's a resident of Minneapolis and if his identity becomes known in his neighborhood? The dynamics that are going to go through that individual's head are almost inconceivable to me.
These kinds of issues, then you also get access to internet and information that's available. I mean, on my cell phone, I can have access to all the news media in the whole United States as fast as I can use my thumbs. It's very hard to keep the control over what information goes to people. I can imagine that they'll only be allowed to make communications with their family while somebody else is present. I mean, this is a burden, and it'll be a very difficult responsibility.
You know, the real central question here is going to be asked of Dr. Andrew Baker, who is the Hennepin County pathologist, medical examiner. That medical examiner's office is historically one of the best in America, and it's been revered for years with John Coe, Gary Peterson, and now Andy Baker. The Hennepin County Attorney's Office depends on Andy Baker's opinion at least 100 times a year, or probably more. And he's going to be asked the question, can you say to a scientific certainty that but for Derek Chauvin's knee on his neck, this man would not have died? And based on what's drifted out, I don't think he can answer that question the way the state wants, and that's going to be a major problem, especially when the defense brings out that how many cases have you relied on Dr. Baker's opinion to get convictions?
These are hard cases, and it will test the most sophisticated work. It will also test the ability of the court to handle the kinds of complexity. It is always interesting as a judge. Once again, you got 50 balls in the air, and you just want them, you don't care where the balls come down, you just want them to land fairly, and you want to keep the game on the, keep the train on the tracks. It'll be quite an experience.
Well, Joe, you mentioned, you tell the jury they'll become better people. I think that, I guess I feel challenged that there will be a need to try to separate the facts from the emotion, which has all gotten jumbled together and
I don't know if humans are quite capable of doing that.
Right. Well, yeah, right. So
the facts are also, the emotions are very much part of the facts in this case. They may not be part of the evidence exactly, but everybody reads the paper, people turn on their televisions, and those things become important. But like I said, it's one thing to make those snap decisions, and it's another to analyze things that take place over time, where this is known and this is known and this is known and this is known, and then the question is, what is the upshot of what is known. And that is the contest that winds up being tried.
Joe Friedberg, Jim Rosenbaum, I thank you so much for doing this with us. I have long admired both of you, and I'm really happy that you made time to talk.
Throw roses at me. Call my wife. Tell her.
Call your wife too, right, Joe?
Yeah, yes.
Thank you.
She's enjoying herself. She doesn't care what I do.
Thank you too.
Thank you so
Thank
much.
you. Nice seeing you, Jim.
Thank you. Joe, it's a pleasure. Take care.